Hi guys, this is Alan. I hope you're having a good lockdown, or at least an interesting one. I'm going to be talking about the criminal justice system in England and Wales. For historical reasons, Scotland still has their own separate system. The system is kind of complicated, and I will simplify it to some degree, as it's about 900 years of history all thrown together. They are trying to simplify it and come up with a better structure, but for now we have what we have. The Magistrates' Court is the lowest court in the system, and it's presided over by 3 lay judges. So these judges are non-professional. They volunteer their time and work approximately 60 days a year as judges, and the rest of the time they have a normal job. Almost all criminal trials are seen on the magistrates level, but most of the more serious ones are passed further up the chain to the more senior courts, because a magistrates court can offer a maximum sentence of 6 months or 12 months for multiple cases. A legal professional who is an expert in the law assists these judges and basically guides them as to what is appropriate in the trial and how, for example, how the defendant should be charged and what sentence they will get if the magistrates decide that the defendant is guilty. As well as criminal magistrates' courts, there are also family courts and civil courts on that same level, but we're going to concentrate mostly on criminal cases and defendants. Crown courts are the higher courts, and they can prosecute any crimes that have been passed on from the magistrates' court or appeals to decisions that have been made in a magistrates' court. Cases in Crown Court generally have a 12-person jury, and the jury are the people who decide whether the defendant is guilty or not guilty, and the judge then decides the punishment or the sentence for the defendant. Crown Court sentences can cover everything from community sentences, where the defendant is made to pay back the harm they have done to their community, all the way up to life imprisonment. If any defendants want to appeal their case, then the next level is to go to the Court of Appeal, where they can make an appeal, obviously, about either the verdict that they were guilty or not guilty, or the punishment that they received, the sentence they received for being found guilty. To have a case heard in the Court of Appeal, you have to apply, and they will decide whether your case has enough merit to be taken on in the Court of Appeal. After the Court of Appeal, there is the highest court in the land, which is the Supreme Court, but this is only used for very important, high-profile cases or ones where the use or interpretation of law needs to be decided. The Criminal Prosecution Service is an independent organisation that handles all prosecutions in England and Wales that have been handed to them by the police or other organisations that are responsible for investigations. The CPS is completely independent from the police and the government. They decide what cases should be prosecuted. They determine the charges in very serious or complex cases, and they also assist the police in the early stages of an investigation. Prepare cases and then present them in court. They also provide information and support to prosecution witnesses and the victims of the crimes. The defence is generally handled by two types of lawyer. There are barristers and solicitors. Solicitors handle the cases in the lower courts, in the magistrates' courts, and barristers generally handle all the cases in the Crown Court and beyond into the appeals courts. Barristers can be distinguished from solicitors because they have to wear the full uniform with the wig and the gown. Barristers primarily work in the court and plead the case of their clients in front of the judge, whereas solicitors have a more all-encompassing role and will often do more work in an office setting. Judges control the trial, and their main job is to make sure that everyone involved gets to hear their case heard and considered as fully and fairly as possible. The judge plays an active role in the trial, making sure everything is conducted with all the laws and practices that are expected. If the jury decide that a defendant is guilty, then it is up to the judge to decide the correct sentence for the crime. The sentence for the defendant is based on a few key factors, including the impact of the crime, guidelines and precedent from previous cases, and the overall circumstances of the case. Mitigating factors that may lessen the sentence of the defendant, such as mental health, are also considered at this point. The judge's uniform is quite eclectic, or appears so these days. The wig actually only started being worn around the late 1600s because it was popular for the nobility to wear around that time. Eventually, the nobility and normal people stopped wearing wigs, but it became a part of the judge's tradition. Eventually, the very long wigs were shortened for trial use, but they still wear the long wigs for ceremonial purposes. The black cap shown here is based on traditional Tudor headwear from court sessions and was traditionally worn when passing a sentence of death. However, capital punishment was abolished, gotten rid of, in 1969 in the UK, so there is no more need for the black cap. Judges and magistrates make two oaths when they are sworn in. They swear their allegiance to the current monarch, currently the Queen, and they also swear a judicial oath. Bye guys, hope that was interesting.